recognition, challenge, and enforcement of foreign awards in India. Now, why do we have three expressions before foreign awards in this title is what I'd like to throw light on first. Recognition, because a foreign award can be in an alien language, a language probably which is not the language of the court. A foreign award can be subject matter of a different system of law. We have a common law system which we've inherited from the Commonwealth in India. But there are several kinds of legal systems all over the world. And in those legal systems, arbitrations are also conducted as per the substantive law of those countries. And therefore, the legal system, the manner, the method, the procedure, and so on and so forth. So therefore, when it is an award of a foreign country, we will get to the reciprocating territory and the New York Convention a little later. But if it's of a foreign territory, it's not a final binding adjudication by an authority within India who is otherwise empowered under Indian law for deciding disputes between parties. So what is naturally legal, what is naturally binding to parties within India because it's been decided by a court of appropriate jurisdiction or a tribunal which has been vested with jurisdiction in the Indian scenario does not in that sense have the same kind of footing or the same platform for its recognition, and therefore recognition comes before everything else. Well, once that award is placed before an Indian court for the purpose of being recognized, there must be an opportunity to the party who has obligations under that award to question it. Question it for the reason that the questioning so far as the jurisdiction where the award is made is for that jurisdiction to examine, for the arbitral tribunal to examine, for the courts which would hear appeals in that jurisdiction to examine. But so far as Indian territory is concerned, it has received the award for the first time. And if Indian territory has received the award for the first time, there surely must be a entry gate or must be a platform where it is possible and it is open for the judgment debtor, if I may express, the party against whom the award has been passed in a loose manner, or to question, because there could be situations where, for example, no notice has been received by the judgment debtor ever in regard to the arbitral proceedings in which there has been an award passed against the judgment debtor. Or, for example, there was no fair opportunity. Or, for example, the principles of natural justice were not met with in the proceedings which were conducted, or the arbitral tribunal passed an award in regard to subject matter which was beyond the scope of what was referred to him or what could possibly be referred to him under the agreement relating to arbitration between the parties. So these are threshold points as are provided for under the statute, but we will discuss them in greater detail. All that I want to convey is that the challenge part of it is the judgment debtor getting an opportunity before the decree holder or the award holder in the present case is permitted to take steps against the property or against the person, as is an available option in execution in regard to a money decree or a decree for specific performance or any other decree that a civil proceeding can result in. So therefore, the recognition in that sense is stage one. The challenge is a stage which is embedded in the recognition, but yet a separate stage. And once that stage is over, that means the recognition is done and the challenge is rejected. It is at that stage that it is open for the award holder to thereafter proceed to take steps for enforcement of the foreign award. So with this little background in regard to what is the scope of our discussion today, I proceed to briefly just highlight what we are going to discuss today. We are going to speak for very, very little time on the history of arbitration in India. The reason why we need to speak of the history of arbitration in India is to understand the present provisions in a proper perspective. A brief outline of the history is always necessary so as to it enables us to understand as to how the present state of law evolved itself from where it was to where it presently stands. After that, we'll have a short discussion on the enactment of the Arbitration and Conciliation Act 1996, which is the statute under which presently enforcement of foreign awards is undertaken. After we discuss briefly the broad structure and the provisions generally of the Arbitration and Conciliation Act 1990, we shall get to the topic of discussion. That is the first part or the first limb of our title. That is, what is the process and what are the steps that a party in whose favor a foreign award exists needs to take for the purpose of recognition of a foreign award, as to what is its meaning and the steps that are to be taken by such party to ensure that that foreign award becomes capable of enforcement and the party is able to enforce the said foreign award. Now, after that comes the frictional part, the tug of war part, the part where all of us as lawyers get involved, because the earlier part is really speaking a procedural part or a ministerial part. Well, the tug of war part or the dispute part or the frictional part is the part where the judgment debtor decides that no, so what if I have an award against me? So what if I have lost in an appeal in the country where that award has been passed? I will still desire to, and I propose to resist the execution of the award against me or my property. In that situation, there is a challenge laid by the decree, by the judgment debtor, when that foreign award is placed before a court for recognition to take further steps in execution. Now, these challenges need to be understood very clearly so as to enable us to attend any matter relating to a foreign award, whether we are for the judgment debtor or for a decree holder. And the golden principles in regard to what are the grounds of challenge in relation to a foreign award are enunciated in section 48 of the Arbitration and Conciliation Act 1996. When we get there, we shall also discuss in brief 10 leading judgments passed by the High Court and by the Supreme Court all the way back in the late 1970s till as recently as last month. These judgments start with the celebrated Renu Sagar judgment of the Supreme Court and lastly refer to the Centrotrade Mineral judgment, which has recently been passed. So we will refer to about 10 judgments which broadly set out the entire law in regard to recognition, in regard to challenge, and in regard to enforcement of foreign awards in India. After that, the next topic which we shall embark is how does one execute a foreign award in India? Now the answer is simple. Just like a decree holder who has a valid decree, that is a decree which has been passed by a court of competent jurisdiction, a decree which hasn't been stayed, and a decree which is capable of execution, just the way the decree holder would apply for execution of a decree under the provisions of the Civil Procedure Code, the Arbitration and the Conciliation Act draws for its utility, draws for the purpose of enforcement of a foreign award, the provisions of the CPC and specifically Order 21 in particular, for the purposes of enforcement of foreign award. So therefore, all the steps that a decree holder would take under the Civil Procedure Code for enforcing an Indian decree against a party would equally be applicable, albeit with slight variations in regard to procedure, a few changes in regard to steps to be taken, but otherwise all the possible weapons which are available with a decree holder are also available to an award holder in order to proceed against the person and against the property of the judgment debtor as is deemed fit by the award holder for the purposes of ensuring that the fruits of the award passed in favor of the award holder are received by him. Now, after that, we shall have a short discussion on the conclusion and the way forward. That is, how does India as a country see things moving ahead insofar as foreign awards is concerned. Now, that is therefore broadly the long and short of what we are going to discuss today, friends. And with that, I start with our first part of the discussion, that is the history of arbitration in India. Now, we are all familiar, either as students of law or as practicing lawyers or as other professionals like chartered accountants, company secretaries, MBAs, corporates, that money is the single most important part of the entire environment of business. And when monetary obligations are not met or contractual obligations are not met, uh, parties whose obligations are not met suffer tremendously. And sometimes because they are at the breach end of monetary or contractual obligations, the, the sufferance is so large that it results in the drowning or the insolvency of the company who has faced the breach. It is with that perspective in mind that over a period of about 2 centuries or more, the present statute as governing commercial contractual matters is found in the form of the Arbitration and Conciliation Act 1996, as amended substantially by the Amendment Act of 2015, which simplifies the act, which makes things less complicated, which leaves lesser scope for courts to interfere, and most importantly, puts a deadline, a timeline upon arbitrators to decide arbitration cases which otherwise were going on for years and years and were in fact behaving similar to the pattern which courts were following, that is not deciding a dispute between parties expeditiously and promptly, but dragging it for a very, very long time. So, well, we all know that pre-47, the British ruled India. And while the British ruled India and India suffered under their hands, the British were prosperous. They had an excellent legal system in place. And once they started putting things in place in India, one of the many, many things which the British put in India were the earliest provisions relatable to arbitration in India. But even before we come to that, we know that we have what is a very vibrant village panchayat system in India. And that village panchayat system is actually a set of 5 people who sit under what conventionally we understand is the village banyan tree, and they hear people on both sides. 5 of them confer with each other and give a decision, and that decision is supposed to be followed, respected and complied with by both sides. So as far back as in 1772, there are traces of the village panchayat system operating on lines of what we today understand as arbitration. And there were regulations having statutory flavor, which were issued by the government at that time, which enabled village panchayats to undertake arbitrations under those regulations. And that was the old model law operating at that time, which thereafter can be traced back till 1899. Now, 1899 sounds not as far as 1772 probably, but yet it is not so close, in the sense a good 130 years have passed since then. So 1899 is the oldest law which can be traced back to referable to arbitration, when the Legislative Council thereafter enacted the Act of 1889, which is the Arbitration Act of 1889. Now, this Act of 1889 was applicable to presidency towns, but it did not have any provisions which are relevant so far as our discussion today is concerned. It covered only domestic arbitrations, and it dealt with only issues which were happening within the territorial jurisdiction of the British India at that time, and between people who were doing business over here and were concerned with transactions over here. Then things moved ahead, and a good 51 years later came the Arbitration Act of 1940. Now, the Arbitration Act of 1940 was no different in the sense of scope from the Act of 1899, and that Act of 1899 covered only domestic arbitration, and so did the Act of 1940. But there were a lot of developments which were happening in the interregnum, and those developments were not really India-centric but global. You all remember that we had World War I, and the World War I devastated the economies of the Western nations in particular and globally in general. It was during that time that it was felt that there needs to be a standardized unified system globally for the purposes of enforcing of foreign awards. And therefore, by the time the World War I ended, several countries of the Western world got together and drew up what is known as the Geneva Convention, which originally was the Geneva Protocol of 1923 and eventually became the Geneva Convention of 1927. So thanks to World War I, that world leaders and countries all over the globe got together and put together or weaved together a statutory provision in regard to every country and a overall convention between the countries which operated between all of them. And to the good fortune of our nation today, India was a party to both the Protocol of 1923 and the Convention of 1927. And because it was a party to the Protocol and the Convention, in addition to the Act of 1940, that is the Arbitration Act, which was invoked till the 1996 Act repealed it, India had what is known as the Arbitration Protocol and Convention Act 1937. This act, that is the Protocol and Convention Act 1937, effectively was to implement the agreement arrived at between countries all over the world as contained in the Geneva Protocol and under the Geneva Convention, effectively meaning that countries globally who were signatories to the convention and the protocol, if they held arbitrations on their soil and awards were passed, those awards, after following a particular procedure as was contemplated, would be recognized and capable of enforcement in the country where the award holder wished to enforce them. And if that country happened to be India, India being a signatory and having a statute providing for implementation of the award, did provide that the award could come to India even in pre-independence times, that is even when the British were ruling India, and those awards could be enforced in India, albeit after following the procedure as was contemplated under the Act of 1937. Now, in the course of implementation of the Act, it was found that there were several shortcomings. The award holder had in the first place struggled to get an award in its favor, probably sustained that award in an appeal which was preferred by the judgment debtor, and yet even after coming to another country to enforce it, it was found by virtue of the provisions of the Geneva Convention and the Geneva Protocol that the burden still remained on him to ensure that he would produce proof of finality of the award. He would get a declaration given by the National Court of the seat of arbitration, and that he would have to establish that the award had been given pursuant to a submission to arbitration which was valid under the law applicable to such arbitral dispute. Now, this was a very heavy burden to carry, especially on a decree holder who has already succeeded in an arbitration and there is an award in his favor. There was no necessity to put this burden on him again. There was no necessity for the decree holder to discharge that burden again, especially because it would mean that the judgment debtor who had lost in the arbitration proceedings, not succeeded in having that award set aside in any appeal or petition preferred by him, was yet able to retain the burden of establishing things on the award holder who had already discharged it by succeeding in the arbitration proceedings. Now, after this was noticed and came the Second World War, and post the Second World War, probably the trade and commerce between the Western world in particular and globally increased to a greater extent. It was found that with increase in global trade, with increase in more and more supplies being made cross-country, cross-continent, and whenever there is business, whenever there is trade, there is every likelihood for there to be disputes. And it is those disputes which need to be put under a governing slot for the purpose of ensuring that the wronged party would not need to suffer just because it is a trans-border transaction between parties. Now, to combat these difficulties, there was a New York Convention of 1958 which was brought in place. And friends, till date, the New York Convention rules the field. So from 1958 till today, the mother provision in regard to enforcement of foreign awards on a global basis is the New York Convention of 1958. Now, this New York Convention had learnt a lot from the Geneva Convention application, from the enforcement of the Geneva Convention and Protocol, and realized the mistakes that lied within, which were being taken advantage of by the judgment debtors under arbitral awards. Therefore, what was put in place was a simple and effective method of enforcement, taking away the burden on the award holder in regard to establishing the various things which I just mentioned earlier. And with that is the 1996 Act, which came about, of course, in the year 1996, repealing three statutes: the statute of 1940 dealing with domestic arbitrations, the statute of 1937, which related to the Protocol and Convention of Geneva, and the statute of 1961, which was the Foreign Award Recognition and Enforcement Act, which was passed on the basis of the provisions of the New York Convention of 1958. Now, the 1996 Act, therefore, what it did was it repealed on the one side all these three statutes and consolidated the law in regard to domestic arbitrations, as also arbitrations held globally, either covered under the Geneva Convention or the New York Convention, and therefore made provisions in great detail in Part 2 of the 1996 Act, Chapter 1 relating to, of course, the New York Convention, and Chapter 2 relating to the Geneva Convention, and in great detail providing the various steps that a party would require to take for the purposes of having recognized a foreign award in India, and the challenge process to be adopted, and if the recognition and challenge process went through, then how would an award be capable of enforcement despite it being a foreign award against a person or against a property which was within the territorial jurisdiction of our country. So therefore, the 1996 was a great reform, a big change from the 1940 Act. And the single most important thing which strikes me is the doing away of what was known as making an order a decree of the court. Let me just revisit that provision. Under the 1940 Act and similarly under the 1961 Act also, any award, whether a domestic award or a foreign award, required to be filed before a civil court, and an application needed to be made calling upon the court to make it a decree of the court. Now that procedure was unnecessary, it was cumbersome, and it was extremely time consuming. It used to take months and months and years for the court to be able to eventually pass an order of making it a decree of a court, and it gave one more opportunity to a judgment debtor who was in any case a defaulter so far as performing of obligations under the award are concerned, to raise questions of all sorts. And with the existing pendency of cases in our civil courts, it was just a free run for the judgment debtor who was otherwise already having failed in performance of his obligations, first under a contract and thereafter under a lost arbitral award. So therefore, that is the most striking do away, so to say, in the 1996 Act from the 1940 Act and the 1961 Act dealing with domestic and foreign awards. Now, what is the scheme of the 1996 Act? Part 1 is the part which deals with domestic arbitrations, and Part 1 on the whole does not apply to Part 2, which deals with enforcement of foreign awards, except the provisions relating to interim reliefs and appeal from the interim relief which is granted. Therefore, Section 9, Section 27 and Section 37(1)(b) and 37(3) are applicable to Part 2 by virtue of the proviso to Section 2, subsection 2 as added recently, and therefore from Section 1 to Section 43, which comprise of Part 1 of the Arbitration and Conciliation Act 1996, only these three provisions are applicable in relation to foreign awards. Now, after Part 1, Part 2 is the relevant part. So insofar as our present discussion is concerned, in Part 2, we have initially provisions relating to the New York Convention that is contained in Section 44 to Section 60, And thereafter, we have the chapter 2 in it, in which there are provisions relating to the Geneva Convention. I must tell you all friends, it is duplication, it is repetitive. But the Geneva Convention provisions are almost a replication of the New York Convention provisions. And there is really speaking no great difference between both the provisions, except the date when the award is passed. And therefore, it is really speaking, the provisions relating to Geneva Convention are an obsolete portion of the Arbitration and Conciliation Act. And at some good time, wisdom should prevail, and our legislature should do away with chapter 2, part 2 of the Arbitration and Conciliation Act. After that is part 3 again, which deals with conciliation, which is a totally separate area of law, which we are all aware about, but not part of today's topic. And part 4 contains supplementary provisions, which are also not part of today's topic. Now, therefore, having understood broadly the scheme of the Arbitration and Conciliation Act 1996, let us just focus on what is really a foreign award. Now, a foreign award is an award made after a particular date. Particular date I say because it should be made after 11th October 1960 if the New York Convention has to apply to it, and after 28th July 1924 if the Geneva Convention has to apply to it. So if it's an award between 1924 and 1960, the Geneva Convention would apply. And if it's after 1960, then the New York Convention is applied. And that is exactly the reason why I said that the provisions relating to Geneva Convention are almost obsolete, and there are no cases, because the New York Convention has been in application, in vogue, and the dispensation as provided for under the New York Convention is applicable from 1960. That is a good 60 years before today. So if an award hasn't been enforced in the last 60 years, then in any case, I don't think it should continue to, take time of the court and parties at all. So with that, I was on the foreign award so in addition to the date, we all understand that an award should be a decision. That decision should be based on differences between parties. Those differences between parties should arise out of legal relationships. Those legal relationships could be contractual or non-contractual. And lastly, such legal relationships should be considered as commercial in India. As the last important facet, that it must be in pursuance of a written arbitration agreement to which the New York Convention applies, and must be made in a notified reciprocating territory. Now, what is a notified reciprocating territory? A notified reciprocating territory is a country with whom our government, that is the government of India, has entered into an agreement where there is bilateral recognition of awards passed between the two countries. Meaning thereby, if an arbitral award is passed in India, that country will recognize it. And if an arbitral award is passed in that country, India would recognize it. That is the reciprocating territory principle which India has followed. And therefore, there are two sides to it. In the real sense of the word, every country who is a signatory to the New York Convention, their award is liable to be recognized and ought to be recognized by India. But India has taken a position, and in my opinion, rightly, that if the country who is a signatory to the New York Convention does not choose to recognize an award passed within the territory of India, there is no reason why India should extend the same reciprocal treatment. And therefore, two signatories to the New York Convention is the first need. And the second need is, that the country should be a reciprocating territory. And that's the requirement. It's quite similar to what our difference with lawyers from Great Britain is. Great Britain as a country wants its lawyers to practice in India. And all these years, we have had a reciprocal demand that if our lawyers are permitted to practice there, you are welcome here. And that is the case with the general foreign lawyers, which our country and our Bar Council has been maintaining. So reciprocating territory principle is a fair, is a balanced principle. It's a principle of equality, and our country has maintained it, though there is some criticism in that regard, because the spirit of the New York Convention somewhere is felt to have got defeated, because a country is signatory to the New York Convention, but yet the end result of that country's foreign arbitral award does not, or being recognized, is not being met with. So, that's a little work to be done probably by our government and government of other countries insofar as reciprocating territory agreements are concerned. Now, what is the applicability of the 1996 Act to? Well, the 1996 Act is a straightforward new statute, which, as I told you, repeals the earlier three statutes and provides for a simplified system under which arbitrations are held domestically, and recognition and enforcement of arbitral awards which are from other jurisdictions, that is foreign awards, is undertaken. Now, a question would arise as to what is the substantial difference insofar as enforcement of a foreign award is concerned between the earlier dispensation, that is the 1961 statute, and the present Arbitral Act. Now, that was enunciated by the Supreme Court in the case of Thyssen versus Steel Authority. And I mentioned to you all earlier that there is not much difference, except that under the present statute, there is no necessity for a foreign award to be filed in court, and thereafter there needs to be a judgment pronounced that the foreign award should be treated as a decree of the court, and that it is the force of a decree of a court. Under the provisions of the present statute, the moment there is recognition of the foreign award, it is deemed to be a decree of the court and therefore enforceable straight away. So that is the substantial difference, and as I pointed out, a great deal of time, energy, and money was lost in having to get a pronouncement from a civil court that a foreign award is a decree of our court and therefore has the force of a decree and should be treated as a decree. Now, moving ahead, therefore, having broadly understood the contours of the general provisions of the Arbitration and Conciliation Act 1996, we move to the provisions which govern foreign awards in particular, that is part 2, chapter 1. And therefore, the first thing which we shall discuss during the course of that is that how is a recognition of a foreign award to be undertaken by a court, and how are steps to be taken by a party in that regard. Now, as I mentioned to you all earlier, Article 3 of the New York Convention provides for recognition of arbitral awards by each contracting state as binding. Enforcement of awards has to be in accordance with the rules of procedure of the territory where the award is relied upon, that is India, if the foreign award is brought to India for enforcement. And thereafter, under section 44, only those awards are to be recognized which are from reciprocating contracting territories as notified by the government of India. India has notified about 50 territories so far, and the simple principle is that a country gets notified if there is a contract between India and that country, and there is a reciprocal treatment given to awards passed in our jurisdiction. Now, a question arises: what if a country is a signatory to the New York Convention, but or it's a non-convention country, and it is also not notified? Well, the simple answer is part 2 of the Act will not apply to it, and for enforcement of an award from a non-convention country, or a country which is a convention country but a non-notified country, a civil suit will have to be filed on the strength of the binding arbitral contract, and a decree be obtained in the civil suit from a civil court in India. And it is only after that that it is possible to ensure that the decree is put in execution. So, it's a short route versus a long route, and that's what the legal provisions say. Now, what are the steps is what we need to know in order to understand as to when a foreign award lands up on your table, either as a judgment debtor's lawyer or as a decree holder's lawyer. as to what you should be examining. Because if you happen to be advising the decree holder, that is the award holder, then you need to obtain a duly authenticated original award. You need to obtain an original arbitration agreement, a translation if it is not in the language of our country, and along with that, you need such evidence that is necessary to prove that the award is a foreign award. And you have to gather all these documents and file them before the High Court having original jurisdiction to decide the questions forming subject matter of the arbitral award, if that dispute had been subject matter of a suit. And in other cases, the High Court, which would hear appeal from decrees of court subordinate, and that High Court is entitled to deal with the recognition, the challenge, and the enforcement of foreign awards. Now, therefore, we need an original award, an original agreement, such other evidence and translations, and we go to the High Court, either the court which would have jurisdiction if the subject matter had happened locally, or the court which would hear appeals. But it goes basically to a High Court and it doesn't go to the other courts, as the situation entails in Bombay. Now, there is an interesting judgment of the Supreme Court in the case of PC versus Ostbulk, where the Supreme Court made it abundantly clear that the requirements of Section 47, though the expression used in the section is shall, the meaning to be given to it is may. Therefore, an application, even if defective, should not be rejected, but party should be given an opportunity to cure the defect. Now, that view was taken and the meaning to the expression shall was to be read as may, because the court recognized that the object of the New York Convention was to ensure a smooth and swift enforcement of foreign awards, and therefore to ensure that the purpose is achieved, the court gave a liberal meaning to the expression shall. In another case by the Supreme Court, that is First Day Lawson versus Jindal Exports, the court clarified that there is no necessity or procedure for filing the award and making it a rule of the court, and therefore this is a speedy and alternative solution to the dispute, and therefore the old procedure cannot be insisted upon at all. The enforceability of the award in regard to the provisions of section 47 to 49 have to be effective and have to be as prompt as possible, and therefore there is no question of making any foreign award as a rule of court or a decree again. Now, that is therefore an abundantly clear position enunciated by the Supreme Court clearly, that well, here you have a foreign award, here you have clear-cut provisions of the Act, an objective which is intended to be achieved, and therefore there is no necessity to put parties through a complicated or a tedious or a cumbersome long process before the award is permitted for execution. Now, the next question when arises and is relatable to the recognition of an award, which should come to the mind of all students and lawyers, is what is the limitation period applicable for the purposes of filing that foreign award in India? Now, there are two interesting judgments, one by the Bombay High Court and one by the Delhi High Court. The Bombay High Court judgment being the judgment in the case of IMAX Corporation versus ECT Entertainment. Now, in that judgment, the Bombay High Court held that Article 137 of the Limitation Act would apply, which prescribes a period of 3 years, and the court placed reliance on the first Lawson judgment, which I referred earlier, and held that since foreign awards are stamped as a decree and a decree can be enforced and is executable is one and the same, Article 136 would apply. Now, Article 136 prescribes the limitation period of 12 years for a decree, and I reckon this is the correct view taken by the Bombay High Court. However, Kane India versus Union of India, the Delhi High Court had an opportunity to examine a similar question, and the Delhi High Court heard arguments by both parties and made a division between what we understand as an application for execution versus an application for recognition, and post-recognition and upon rejection of the challenge process, it being executable as a decree. With all that discussion, the Delhi High Court held that Section 47 deals with the first and the second stage, and once an award passes the gateway of Section 47, it is treated as a foreign decree. And that foreign decree, if it can be enforced in that country where it is to be enforced for a lesser period, then how could it be enforced for a longer period in India? And with that background, it held that Section 49 presupposes that foreign award is a decree whose execution can be impeded by a party who can discharge the burden under 48, and therefore 136 would apply to enforcement petitions. But so far as foreign awards is concerned, 137 applies, since execution petition is akin to an application. So therefore we have these two positions in India, and therefore the safer route is to apply for recognition of a foreign award as early as possible and not wait for very, very long. Now the next topic, which is an interesting topic for all of us, is what is the challenge that a party can lay in regard to a foreign award when the award is placed by the decree holder before a court for the purposes of its recognition, before which it can be enforced. Now, there are some golden principles laid down by the Supreme Court and the High Courts in several judgments. But before that, the simple language of Section 48, 1, provides the general principles and circumstances under which a recognition of a foreign award can be successfully resisted by a decree holder. And those circumstances, to put it simply, are: was there some party under an incapacity or an agreement which was invalid to which it was subjected? If that is established by the party against whom the award is passed, then that party would succeed and the court would hold that the recognition of the foreign award is not possible. Similarly, if the party is able to show that the arbitrator was appointed without proper notice, or the party was unable to present its case because of absence of proper notice or otherwise, in that case also the court would examine the merits of that contention, and if those contentions were found to be correct, hold that the foreign award would not be recognized and not capable of enforcement within the territorial jurisdiction of India. If the award is dealing with differences beyond the jurisdiction of the arbitrator, if the composition of the tribunal is not in accordance with the procedure contemplated, or if the competent authority in the country where the award has been passed has set aside the award, are also circumstances under which a foreign award would not be recognized by a court in India. But with all this, we must remember what I said in the beginning of our discussion, that the onus to prove that the enforcement of a foreign award must be refused is upon the party who is resisting the enforcement, and not like it was under the Geneva Convention of 1923, that is on the award holder who presents the award for the purpose of enforcement. So therefore there is a shift of burden from the award holder who has already taken the pains and now wants the fruits of his success, to the party who has lost the cause and thereafter resisting the enforcement of the award against him. Now, from Section 47, which is the procedural section as to what is required, and 48.1, which gives the general principles as to when the party against whom the award has been passed is able to resist the recognition of the award, there is a substantive provision under 48.2, which further provides as to the scope of challenge under the Arbitration and Conciliation Act. 48.2 provides that if the subject matter which is decided by the arbitral award is not capable of settlement by arbitration, or the enforcement is against public policy, in both these cases also the court would step further and prevent that award from being recognized for enforcement in a court in India. Now we shall discuss in greater detail the scope of these two aspects, that is subject matter not capable of settlement by arbitration and enforcement being against public policy. But before we do that, we must briefly refer to the provisions of Section 48.3, which are a scenario where the award in question is under challenge before another country. For example, if an award is passed in London, and the party against whom the award is passed carries the award by challenging it before the Chancery Court in Great Britain, and that petition or appeal against that challenge is pending. Now, pending that challenge, if the award is brought to India for the purpose of execution, what 48.3 provides is discretion to the judge to adjourn the proceedings till such time that that competent authority, that is the appropriate forum in the country where the arbitral award has been passed, decides on the award, until such time the court is equally vested with jurisdiction to call upon the judgment debtor to give security in case he doesn't want the award to be proceeded with against him. Now, therefore, these are the general provisions under 48 so far as challenge is concerned. Under 48.1, as we have seen, 48.2, and thereafter 48.3. Now, these have been in operation from a very, very long time within India. And therefore, under the Act of 1961 and before that under the Act of 1937 and now under the Act of 1996 amended by the Amendment of 2015, courts have time and again taken up cases relating to enforcement of foreign awards, heard arguments on diversity of challenges, and set out some principles which, if understood clearly and properly by all of us, are actually a permanent Bible in the mind when it comes to a case relating to enforcement of foreign awards or challenging the recognition of a foreign award in India. And those principles can broadly be summarized as follows. The first principle which a court applies when it takes up a recognition of a foreign award and examination of a ground of challenge for a foreign award is the scope of refusing enforcement under section 48 is extremely narrow. That is the jurisprudence which is required to be followed by a court when it takes up a case, that it must understand that its scope is very narrow. The court must also know that its jurisdiction is not to review the case on merits. Its job is therefore not the job of a court who examines what is the decision on merits and thereafter reviews it on the basis of asking itself the question, is the award on merits right or wrong? That power of review is not part of the jurisdiction of a court under section 47. The next is, nor does the court exercise appellate jurisdiction over the foreign award, nor is it supposed to inquire into whether, while rendering the foreign award, were there procedural defects that have been committed in the course of conducting proceedings. Therefore, to put it simply, a very, very narrow scope, that scope being restricted in its entirety for not being able to review the decision on merits, nor a decision as an appeal court, nor inquiring into any procedural defects that have been committed during the course of the proceeding before the foreign award is passed. Now, that takes us to the next question as to what is the meaning of public policy. Now, public policy is a very, very narrow expression, but a matter of great debate in case after case all over India. But we shall speak of what exactly is public policy after the clarifications and the explanations incorporated by the 2015 amendment in a little while once we finish these summarized principles. In short, the next point, which is very, very clear, is that contravention of a provision of law is insufficient to invoke the defense of public policy. You can't say that a particular provision of law was not complied with and therefore it is against public policy and therefore please set aside the award. There is a notion called fundamental policy, and that fundamental policy is not contravention of any law, but what it does is it connotes the basic and substantive rationale, values and principles which forms the bedrock of laws in our country. To give a simple example, in our country, a judge cannot be a judge in his own cause. Similarly, you can't decide against a party without giving him a hearing. Similarly, a party who is heard must be disclosed with all data, all documents, all details which are available with the arbitrator for deciding the case. This is our fundamental national policy, and all cases decided all over nationally are decided bearing in mind these principles. Now, therefore, if there is a violation of these principles as a result of which a party is incapacitated and an arbitral award has been passed, that arbitral award would be deemed to be won against the public policy of India, and therefore the court could consider interfering with it. Now, that is therefore an example of most basic notions of justice and morality, and that is something which means what shocks the conscience of the court. But in all these cases, there is a discretion which lies with the court in case the objection relates to interest of party alone to enforce an award, even if a ground is made out under section 48. Because globally, bearing in mind the comity of nations and the interrelations between different countries and their law enforcement systems, it is extremely important that our courts respect arbitral awards passed in foreign jurisdictions and likewise expect them to follow the same for foreign awards passed in India. Now, with that background, I must move to the judgments which refer to the scope of the expression which is provided for under section 48 and how they have dealt with it from time to time. Now, the first judgment is the Renusagar judgment of the Supreme Court, in which there was an interpretation of the expression public policy as understood under the section 7 of the 1961 Act. Now, Renusagar made it very clear that on merits, there is very limited scope available with the court to examine and impeach the award. The public policy in other countries, the court held that the 1937 Act has used the words public policy, which was not followed by the words of India, because there was no public policy for each state in India. But at the same time, the New York Convention does not allow inquiry into violation of law of that country. Therefore, while examining a foreign award, it's not really open for a court to start examining the foreign award in terms of the laws of our country, and after that reach a conclusion whether it is in violation of public policy or not. In that case, that is the Renusagar case, the statute in concern or the statute in consideration was the Foreign Exchange Regulation Act, and it is after consideration of that statute that the court held that FERA is a safeguard, safeguards the economic interests of India, and held that violation of FERA would be contrary to the public policy of India. But in the facts of that case, the court did not find any violation of FERA. Therefore, the court held that disregard of orders of courts would adversely affect administration of justice and would be contrary to public policy. And with that, it summarized the broad principles of not interfering on the merits, not acting as an appellate court, not acting as a court of review, and doing a limited examination as understood and as discussed by us just now. The next interesting case is the Lal Mahal case decided by the Supreme Court. And in the Lal Mahal case decided by the Supreme Court in 2014, the Supreme Court made it categorically clear that the expansion of public policy under section 34 is not applicable to the expression public policy under section 48. Therefore, even though section 34 dealing with challenges to domestic arbitral awards had an expanded meaning to the word public policy as held by the courts and as provided for under the statute, so far as section 48 is concerned, the Supreme Court examined the applicability of the definition as expounded in the Renusagar case, and thereafter held that the decision of the Supreme Court in Fulchand Exports, which had equated the public policy definition as expounded in ONGC, was not correct, and it was on this limited point of public policy that the Supreme Court held and reiterated the principles of it not being a court of appeal, it not being a court of review, it should not look into procedural aspects, and its examination is therefore on a very, very, very limited basis. After all these judicial pronouncements, when the 2015 amendment was brought about, it made a very important clarification or by an explanation in section 48, and that explanation makes it clear that for the avoidance of any doubt, it is clarified that an award is to be held to be in conflict with the public policy of India if it is affected by a fraud, if it is affected by a corrupt practice, or if it is in breach of a fundamental policy of Indian law, or the basic notions of morality or justice. Now, what would be the basic notions of morality or justice or fundamental policy of Indian law was pointed out by me a little earlier. But in one very, very interesting case decided by the Bombay High Court, in the case of Noble versus Dharni, Justice Chagla gave two examples, and those two examples explain what the basic notions of morality or justice would be, or what would mean by the fundamental policy of Indian law. Justice Chagla's examples are that if there is a contract for export of meat of peacocks, all of you all know peacock is our national bird and therefore is a protected species within the territory of India, or if there is a contract for export of elephant tusks from India, again endangered, again to be protected, etc. And if this contract became a subject matter of an arbitration in some country where this was found to be all right, and the Indian contracting party who had agreed to supply peacock meat or elephant tusks lost it, and for enforcement of that award, if the proceedings came to India, what would the court do? And Justice Chagla held that, well, public policy includes drastic, serious national policy matters such as trading in elephant tusks or sale of peacock meat from India. And therefore, in that case, Justice Chagla held some mere improper admission of evidence by the arbitrator as contended by the respondent cannot amount to violation of public policy. He also held that all the objections in regard to coercion, etc., do not reach the threshold of public policy as contemplated under Section 48. There are 2 or 3 other interesting judgments of the Supreme Court in the case of Vijay Karya and thereafter in the case of Alimenta, which all also take similar positions and reiterate the principles which I stated earlier. And now, most recently, we have a Bombay High Court judgment, which has, in a very, very interesting judgment passed only on 30th of April 2020, held that in the case of a foreign award where the subject matter of the dispute was a put option deed, and if the put option deed was committed breach of, as a result of which there was a claim of damages by virtue of the breach, and if that award was passed in favor of the party against whom the breach was committed, what should be the position the court should take? And the court held on the respective objections raised by parties. One, on the question of stamp duty, that it was the obligation of the party who had lost the arbitration to pay stamp duty, and therefore it had to get the stamp duty paid itself, and it could not raise that dispute therefore. The second contention was that the put option deed is a contract in derivatives and a forward contract and illegal under the SCRA. The court examined the intent of the SCRA and the nature of the put option, and it held that there is an exit for the petitioner not to indulge in any speculation in put securities, and SCRA would not be applicable to the transaction in question, and therefore it was further held by the court that the arbitrator's view was not an impossible view, and therefore the court could not stop enforcement or recognition of that award. The one more contention which was raised was relating to FEMA, but that contention was also rejected by the High Court, and thereafter, following the Lal Mahal principle, the court confirmed that the award holder could thereafter proceed in execution. So therefore, this is the legal position so far as challenge is concerned. Now, one interesting question which was recently again decided by the Supreme Court on 2nd June, well, 8 days from today, is regarding two-tier arbitration. And all of you all will remember in 2016, there is a celebrated judgment of the Supreme Court in the case of Centro Trade, Minerals versus Hindustan Copper, dealing with a mother agreement and a daughter agreement and a family agreement and a sets of agreements and so on and so forth. That is several parties and several agreements and several arbitration clauses and so on and so forth. Well, as a continuation of those proceedings, those very proceedings, now what came up before the Supreme Court was that there was a two-tier mechanism. The first tier, the arbitration was to be conducted in India, and if anybody was dissatisfied with the award, there was an appeal provided to the ICC in London for a second arbitration. And therefore, the contention raised by parties was that the enforcement of ICC award, it was unable to present its case before the arbitral tribunal, which was not dealt with by a judge of the Calcutta High Court, who rejected the objection and was also rejected by the court. The Supreme Court sustained the objection and held that the award is unenforceable and remanded it back to the remanded it back to the ICC. Now, there was an argument on the expression otherwise contained in the ground, and it was also argued that it cannot be held adjudictum generis with the words that preceded. Now, the present bench, that is the bench which heard the matter and gave the judgment on 2nd June, negated the contention relying on the Vijay Karya judgment and held that the word otherwise contained in the ground was otherwise unable to present its case, has to be interpreted narrowly. Now, several judgments were discussed, and after applying all these tests, the bench held that the dissenting judgment rendered it factually and legally incorrect, and the bench also held that the enforcing court under section 48 does not have the jurisdiction to remand the matter back to ICC. So that is the recent judgment. All of you all must surely have a look at it. And with that, we come to the next topic, that is execution of foreign awards in India. Now, insofar as execution is concerned, we have under section 51 of the CPC, 5 provisions, that is delivery of property specifically decreed. We have an attachment and sale procedure. We have an arrest and detention procedure. We have a receiver procedure, and we have such further and other reliefs also provided for. Now, under Order 21, Rule 30 to 36 provide for execution and modes of execution, where there are money decrees, where there are specific movable properties, where there are immovable properties, and where there is a specific performance granted. Now, therefore, with all of that, this is the enforcement to be undertaken by a successful party who has in the first place succeeded in an arbitration award, getting an arbitration award, thereafter ensured that it is not set aside in the country where the arbitration award has been passed, thereafter passed the barrier of recognition and challenge, and thereafter should be able to enforce it. Now, well, we have a very, very old Privy Council, golden sentence, so to say, in 1872, that the difficulties of a litigant in India begin when he obtains a decree. And that would in many, many ways, could be said true about reaping the fruits of an award because of the practical difficulties in tracing assets of the judgment debtor, an overburdened judiciary, and the forgiving attitude of the judiciary in so far as adjournments are concerned, in so far as breach of orders are concerned, in so far as not coming clean before the court is concerned, and so on and so forth. But well, this is our state of affairs, and all of us have to together jointly endeavor to ensure that the system improves for the better. But as we presently stand, I think the state of affairs, the state of law, insofar as enforcement of foreign awards, is a very, very satisfactory one in India, with not much scope, not much opportunity, as was there in the past probably, to be able to come in the way of a successful award holder being able to enforce his contract. Well, enforce his award, I'm sorry. So, well, that is the long and short of our topic for discussion today, that is recognition, challenge and enforcement of a foreign award in India.